Good morning and welcome to the Court of Appeals today. We have several matters on our calendar this morning, one of which we will hear oral argument in. That is the case of Sarah Ward versus Meredith McGarry. Counsel, if you could please enter your appearances for the record.
Yes, Your Honor. Angeli Dockage on behalf of the appellant, Sarah Ward.
Julie Nelson for appellee Meredith McGarry.
Thank you both. Both sides have 15 minutes in which to make their arguments this morning. Counsel, it appears that you have reserved 5 minutes for rebuttal.
Yes, that's correct.
I know you both have been here before and are familiar with our calendar and our clock. Do either of you have any questions before we begin?
Not at this time, Your Honor.
I would just remind you to stay close to the podium, speak in the microphone, and enter your appearances every time you take the podium.
Thank you.
Thank you.
Good morning, Justices. May it please the Court. We are here today on an appeal with three primary issues before the Court. To begin with, that the trial court erred in failing to apply the requisite statute. This is really at the heart of our argument here today, where it's something that we feel to be a blatant error. We've been before this court on appeal just 3 years ago, and it was much the same findings because it was a related issue about Mr. McGarry's income and what's being imputed to him. At that time, this court found that the trial court cannot just impute an income to a parent for purposes of calculating child support just based upon what the person being imputed decides they want to be imputed.
Although you'd concede that if we were to agree with the trial court, or we found that the evidence justified a finding that the figure of $18,000 was accurate, that if the parent stipulated to amount greater than that which the evidence established, that would be okay, right?
Well, not exactly, because the prior finding on the appeal in this case was that it's not just Mr. McGarry who has to stipulate to it, it would be Ms. Ward.
I think you're, well,
But I do see what the court's saying about the court's finding of the 18,000, but even
I'm
that.
just saying that if the evidence sustained an amount less than the trial court awards, would you really have a way to argue that a party can stipulate to a greater amount, even unilaterally?
Well, I understand what the court is saying, so
Okay.
I'll address that as far as it being an upward deviation specifically. So the evidence doesn't support it here. So I see what you're saying. If that were the case, yes. But in this case, we're saying it's not at all, not even close, because we've presented the evidence from trial that was set forth that shows, even based upon the taxes, that's not the case. Based upon the bank accounts, even heavily redacted, that's not the case.
The evidence doesn't support what? I guess I'm not
The
following.
evidence doesn't support that the 18,000 finding was his actual accurate or imputed income, essentially. Because the court even previously found prior to trial that it was 20,000. And then there was a stipulation upward. There was an offer for 30,000 settlement. Then at trial, the exact words, I'll just go straight to it because we feel that this is such a blatant error and essentially abuse of discretion by the court. But the error is where the court was having a conversation with Mr. McGarry's counsel saying, so what's your bottom line? What do you believe his monthly income is or should be imputed at? Counsel said 32,000, and then the court says 32,317, like basically what you put in your briefing or on your financial declaration, that's where it came from. And the court asked, and you're saying he's fine with that? Yep. So that's what it was. No one ever asked Ms. Ward what her bottom line is, what she believes it to be. But when you go through the evidence, what our evidence actually supports based upon the taxes and the bank statements, the K-1s, when we look at everything combined, we have a much higher income. So just based upon, if we take Mr. McGarry's actual admitted income off of his financial declaration, that was $32,317.67. But then we have a big problem here because what the Utah code says, as far as the requisite section that is applying here, Utah code obviously has been renumbered, so it's section 81-6-203 4A, rather than the former code section of 78B 12203. Gross income for self-employment or operation of business shall be calculated by subtracting necessary expenses required for self-employment or business operation from gross receipts.
So can you respond to the argument we're going to get from Ms. Nelson when she stands up, which is the framework that you presented to the trial court at closing with the three things? It looks to me like, at least that's what the other side's arguing, is that the three things framework was the way you presented the statutory argument to the court below. And I guess I wonder why we shouldn't apply that same framework now.
That is what we want to have applied. I guess the concern is that the statute, so 81-6-203, it says that this is how it shall be calculated. But then what do we do with unnecessary expenses, personal expenses that are run through a business? The statute doesn't address that. It just says that it's going to be calculated by subtracting the necessary expenses required for self-employment. And even the last sentence of that code section says, only those expenses necessary to allow the business to operate at a reasonable level may be deducted from gross receipts.
Right, but the point they're making is the only ones you identified in closing below that the court should fuss with were the ex-wife's income, the 25% versus 12.5%, which
The
you
court
essentially
did.
won on,
Yeah.
and then the ranch issue. So,
Right.
so aren't we really, isn't your appeal really sort of boiled down whether there was sufficient evidence to support the court's findings on the ex-wife's income and the ranch issue?
So that is part of our appeal. That's what our second issue on appeal is that the findings don't match what the evidence shows. And so that's part of it. But the problem also goes back to the application of the statute, because the court, in determining that $18,000 amount, didn't apply the code section. It didn't apply the statute. It once again went to Mr. McGarry and said, well, what do you want to be imputed at? What's your bottom line? And so
I
again,
would probably have to disagree with that, though. In the findings, the court's findings, the court specifically dealt with the ranch income, or the loss, the ranch loss,
Right.
basically, there was no income. The court specifically found that, Mr. McGarry doesn't control, well, Mr. Meredith McGarry doesn't control the investments of Iron Mountain, and that the purchase of the real property, the ranch, was directed by Roy, and that especially in the agriculture area like this, where it would not be expected that property would generate income immediately, court finds that the fact that the property has not generated income is no way diminishes the notion that it was purchased for legitimate investment concerns by Iron Mountain. And then it makes another specific finding about the credit card expenses, that it's not going to use those. So isn't your argument really that the court's findings weren't specific enough about why it chose not to credit your argument that those weren't legitimate business expenses?
that is part of our argument. We did brief that, and we touch even more on that under section 2 of our argument, where we're saying the evidence doesn't support the findings that were made. But essentially, what we come back to is we're still taking issue and having a problem where we have the code section that says only the necessary expenses for business operation. The code section doesn't say that this could be for future investment purposes. Also, we had dispute and inconsistent statements even from both Roy McGarry and Meredith McGarry about what their business share or percentage was and at what point in time it changed. And then we have the actual records on file with the Utah corporations that show something different. And then we also have Meredith, who raised for the first time at trial that now his wife has a share in this when that wasn't raised previously. And so there's a lot of inconsistency. But again, we also take issue with the fact that the farm loss, depreciation, all of that is being depreciated through Iron Mountain, which is a Utah construction company. This is a farm or a ranch up in Idaho, which we cited to the record multiple times, where they talked about using it for camping and ATVs and horseback riding and this and that. Basically personal leisurely activities that is not at all related to the operation of business. It's not a necessary business expense. And the fact that they're depreciating the ranch through Iron Mountain, the construction company, it wasn't even depreciated through McGarry Land and Livestock, which might actually make more sense for ranching. But they're doing it differently, essentially to decrease his amount of income. I mean, so it is a matter of the findings aren't supported by the evidence, but it's also a matter of application of statute. Because where the court is saying, well, we're gonna just look at his K-1 income. Well, he's still an owner. We still need to actually look at the statute for self-employment. He is self-employed, even though the court's saying he has this lesser amount. But also, I've cited to the record where Meredith and Roy specifically admit that, well, actually, so we had contradicting. So it was Meredith saying, I'm not a controlling partner here. But then Roy had testified, we're in this 50-50. It's joint. We're doing this together. Everything, all these decisions we're making together. That's what I've cited to in the record where he's saying it's a joint venture that we agreed to get this ranch together.
Well, if there's conflicting evidence and the court makes a finding against you, what can we do about that on appeal?
Well, because the evidence, it's not even just the testimony, but it's also the history. Historically, the way that it's all set up, the way, essentially, historically, if you look at the corporations and the change of the ownership, and again, where we show up at trial and for the first time, he's saying, not only did I shift another 25% to my brother, now my wife owns part of it too. So it's essentially him throughout the course of a decade of litigation trying to reduce what his ownership interest is in a company that he himself started 20 years ago. And so clearly this is a hiding of income. The testimony from all parties, there was an acknowledgement and admission that his wife actually works full-time for the school district, and any work she's doing is actually for McGarry Land and Livestock, which they're saying they're joint owners of. We didn't fight that, but then we're saying, then why is she taking half the income, the supposed income from Iron Mountain, when her work is for actually McGarry Land and Livestock, and she's taking a piece of that. So essentially, it's a way for him to, again, shift income to his house where it still, or to his wife where it still stays in his household. And so we take issue with that, and the overarching goal here of Mr. McGarry essentially attempting to have a decreased amount of income imputed to him for purposes of child support, where if you look at his business and what his expenses actually are, if you don't consider the farm loss and depreciation that was taken, that would be another $35,438 added back in just for his percentage share. And that's based on what he acknowledged his percentage share to be and what the court ultimately imputed him at. And then just his wife's payout from the business, again, $4,416. So that would make his total monthly income $72,000 rather than the $32,000 he's wanting imputed to him. Again, when you look at the code section, Utah code, it tells you you can only deduct those expenses necessary for operation of business. He's deducting all these other things that are not necessary business expenses. And so to that point, certainly to that point, we are arguing that the findings just don't match what the evidence shows. And that's where we had cited the Blake case. I know that Ms. Nelson, counsel here, was counsel on that case. And so she's aware where there's no way to explain how he would support the lifestyle based upon an income of just $32,000 a month. Even with his higher income of the imputed, if it were $72,000, because of essentially what the records and documents at trial did show is that he's making millions. He's a millionaire, but yet he's trying to reduce it down. And although this is acceptable for purposes of taxes and taking certain deductions and shifting, as far as child support, it's still to be considered under the Utah code.
Can I quickly ask you about the sanctions issue and the court's finding that although it appears respondent was dilatory in providing some required records, the court cannot find that the delay was an intentional effort to undermine petitioner's ability to prepare for trial. Mm-hmm. Isn't that, what do we, as Judge Harris asked about the court's factual finding or determination, what do we do about that on appeal? I mean, that's a pretty significant finding
It is.
against you.
It is, but that's also coming from a judge who said Sarah couldn't have a trial. And so we have a problem with the lower court who was initially trying to deny due process altogether. And so just because the judge said so doesn't mean that it is in fact so.
Sounds
Where
like
we-
you're litigating the last appeal. I mean, in between the last appeal and this one, there was a trial, no?
No, absolutely. There has been a trial afforded to Sarah because of this court's findings, and the opinion of this court. But I'm not trying to litigate that. I'm just pointing out that there's been significant, I don't even know the exact words for it, but basically significant error by the trial court. And so when we're here again on the same issue where it was already stated by this court that you cannot just impute income based on Mr. McGarry's own, his own request for imputation and what that amount is, that's exactly what happened here again for this appeal.
I'm sorry, I'm not following the connection here, and it's probably me, so I want to give you a chance to clear it. Let's assume the trial court just missed the boat on, obviously, the prior appeal we said, yeah, you have to have a trial, now you've had a trial. Let's assume the court missed the boat on how it calculated things and didn't apply the statute correctly. Even if we were to conclude that there was legal error left and right, that doesn't necessarily inform the issue of sanctions at all, does it?
So what we're looking at here is that we believe the record and the evidence does show absolute intent and improper delay. Because what we have presented to the court is, we have a decade of litigation to show it, but we also had several motion hearings throughout that time.
Well, don't
And-
you have to in your briefing, and I wanted to ask about that. On page 42 of your brief, you say, you filed statements of discovery issues, motions to compel, requests for review hearings to address discovery issues of the court, and finally a motion for sanctions under Rule 11 and Rule 37. Cutting that apart, for example, under Rule 11, I don't see anything in your primary brief or actually in your reply brief that would give us a basis to reverse a Rule 11 ruling that the court made. You claim to be making a motion for sanctions under Rule 11. Under Rule 11, there's a safe harbor provision where you would say to the other side, look, this is what's wrong with your pleading, this is what's wrong with the argument you're making, I think it's in bad faith, and then they have a certain period of time where they can withdraw that pleading. I don't see anywhere in your brief where you've shown, number one, that process occurred, but more importantly, that then you sought for a sanction under Rule 11 and the court abused its discretion in not granting the sanction. So just focusing on Rule 11 for a moment, where do you see that outlined in your brief that there was a problem with the court's ruling on a Rule 11 issue?
So in our briefing, we've cited to the record, and we did have that process, and I've cited to, let me just pull the record number for you. So we've cited to the record of at 4073, 4203, and 4213, where we had brought that motion for the sanctions. We did go through that process, and then where we're saying that the court had made error was that we had also, at the time of trial, the court did not resolve all issues. And so we attached as our addendum D, I think it's D, let me just make sure. We attached where we had the supplemental order from the court. And that is the order on petitioner's motion for supplemental order that we submitted, where we had asked the court to specifically address the sanctions issue.
Right, the court didn't rule on the sanctions, you asked them to rule on that.
Right. And so that's because we felt that the evidence obviously would warrant it or support it, but it's in that lower court briefing and the Rule 11 motion itself where we set forth the grounds for it. We're not asking for this court to just automatically reverse that. We want remand on it. We want reconsideration, maybe looking at it in a more fair manner. Because when we got that supplemental order, essentially for the court to say, well, yeah, he was dilatory in not getting all the documents, but we don't think it was intentional. But then again, then that's why I pointed out.
You're asking us to rule on that, to find an abuse of discretion as a global proposition. You're not asking us to look at individual rulings as to Rule 11 or individual rulings as to Rule 37, which I think is the other rule that you've invoked.
So the supplemental, I mean, the order we're appealing from is that supplemental order, but yes, we're saying there's a general global abuse of discretion on that point, because this is something where, again, there's been over a decade of litigation now. It's devastated Ms. Ward financially. She's raising this child, together with Mr. McGarry, but she's taken out her retirement income. That's devastating to her. That impacts the child. The child not being fully supported when his father's a millionaire. I mean, there's so many examples throughout the record where we can show that this is something where there's just, we say globally. I mean, if you want me to give specific examples, I can.
My question was whether you outlined that in your brief as to specific rulings. So, I mean, can you cite a case where the Court of Appeals or the Utah Supreme Court has taken such a global approach to sanctions instead of looking kind of down in the weeds at specific rulings?
Well, what I can point to is the evidence in this case, which we did outline in our briefing, where Sarah was made to leave the court during a hearing with the commissioner and told to go get tax forms that her employer hadn't even sent out to its employees yet. And she had to come back that same day and present that to the court. And then we have Mr. McGarry, who was told, log into your accounts, let's see your bank accounts. Then he can just say, well, I can't remember my passwords. He could have reset them in the moment, but he didn't. And so again, it's just him intentionally delaying. Previously, Ms. Arnovic was counsel for Ms. Ward, and she had done several discovery motions and requests for sanctions. She was only able to get heavily redacted documents. They were documents that were ordered by the court. Some of the pages were fully blacked out. They were all mixed up. They weren't organized, and then handed to Sarah that way. So again, that cost her thousands and thousands of dollars for her counsel to try to get that organized, to go through all of it, to try to figure out, and to piecemeal between all the redaction. And so again, this is something where the rules are clear about what needs to be provided with a financial declaration, and there's no excuse for Mr. McGarry not complying. It's almost like he's always been the exception to the rule, and it's something where, again, this is not only devastating to Ms. Ward, but it's for the child's best interest. This isn't just money in Ms. Ward's pocket, this is money for the child. And so where we have case law, the Hills case, the Andrus case, the case where there's, Hills v. Hills, Andrus v. Andrus, where children are supposed to be fully supported. And that doesn't, and it should be something that they should be supported to the extent possible, and that support shouldn't be bartered away, extinguished, stopped in any way, or defeated. And this is a case where it is blatantly clear that Meredith absolutely was not compliant. He never gave us a full set of taxes in 10 years until, well, I think at that time, 8 years, until we had trial, and then it was just the 28 days before trial. That was the first time we ever saw a full tax return. And so I don't know how we could say that when we have rules in place under Rule 26 and with the financial declaration requirements, and where there's case law that supports that all parties have to comply with these rules of discovery, and Mr. McGarry just never did. And so I think it is appropriate for the court to take a look at that and to consider the findings on sanctions, and even if not overturning the specific finding at this time, it's something that's worth further review on remand. Does the court have further questions?
Yeah, just follow up one thing on that. I'm looking at page 41 of the red brief, and this is a really long block quote that Ms. Nelson put in her brief from a trial brief below by way of responding to some of these allegations. This is the red brief's way of saying, hey, here's what we did do. And I want to ask you about allegation 46. It's on page 41 of the brief. This is the representation made in the trial brief, is that you all never filed any statement of discovery issues related to inadequate disclosures related to respondents or Meredith McGarry's financial disclosures. Is that true?
No, that's not true. We did file a statement of discovery issues. Let me just pull it up.
Well, the allegation isn't that you never filed a statement of discovery issues. The allegation is you never filed one related to Mr. McGarry's alleged inadequate disclosures related to his financial disclosures.
No, that's not correct.
Okay.
Because I personally filed those, and I know Ms. Arnovic filed them as well. When she was counsel, then there was one other gentleman that was interim counsel, and then I became counsel on the case, and I too also, let me just pull up the citation to the record where we had filed, because I think it's important for the court to see that. There had been ongoing, so they can't say that there was no filing as to the inadequate disclosures or income. We complained of that regularly. In fact, when we went before the commissioner, it was on a different motion before she made the final decision prior to the other appeal, essentially. That ended up being a 5-minute hearing. We were there on other issues before the court, and we were trying to address income at that time. Every single hearing, essentially, that we had in the lower court, when it came before the court, we always complained of the noncompliance with the disclosures. And the court did order it. The commissioner.
Right, but it's one thing to complain at a hearing. It's another thing to actually file a statement of discovery issues or a specific motion. I think this is going to Judge Mortensen's question about what specific things did you file?
Yep, and that's why I'd be
and-
happy to pull it up here for you.
Yeah, when I see this allegation that there was never a statement of discovery issues on this, that catches my attention. I just want to make sure that's true. I'm sure Ms. Nelson will have something to say about it during her
No,
time
that
as
is
well.
not accurate or true. So let me just pull the citation here for the record for you. Okay.
If you want, Ms. Dockich, maybe you could find that.
I've just gotten to it here, Your Honor.
Okay.
So we did do that, and we filed multiple motions.
What's the record citation?
So I'm on page 41 of the brief, so it's record 3998 to 4006, 3991 to 3993, 3954 to 3956, 3996 to 3997, and the record at 5089. And so we absolutely did have hearings on the statement for discovery issues within those citations. And I can do the breakdown when I go sit at table and at the council table here while Ms. Nelson argues, and to tell you exactly which of these record citations that I just stated match with which statement on discovery issues, the motion to compel. We also had the forensic accountant that we had to hire, serving and paying for subpoenas. We did subpoena Meredith's businesses. We also subpoenaed, and they weren't complied with. We also had subpoenas and motions for release of tax documents from the Utah State Tax Commission and the IRS. Of course, Meredith opposed those. He filed a motion to quash. The court had still granted and signed the order, at least for the Utah State Tax Commission. We didn't get the documents from the IRS, but we did get them from the Utah State Tax Commission, which was actually our first insight to his actual income. And that's when Mr. McGarry started to acknowledge that he was making something more than like $11,000 a month, like he initially claimed. And so we had to go through several steps. We did subpoenas to banks and financial institutions. We also subpoenaed numerous witnesses, and those are at record 4805, 4840, and record 5088. And so again, like I said, I'll sit down here at council table and I can match up with the record the exact places where we did have these motions and statements of discovery issues, and also where we had motioned the court to actually get release of tax documents from the State Tax Commission and the IRS because we weren't getting compliant or any discovery production by Mr. McGarry himself. Thank you.
I don't have a record site to respond to that, and I don't know how to handle that at this moment, so I'm going to start at the top. We're talking about child support, not property distribution. That means the only thing at issue is income. If wages are not normal, if parties don't think that the wages are accurate, they have a couple of different ways to go. One would be self-employment, that's true, which all the cases that I'm familiar with in Utah are talking about like cars, phones, home offices, expenses, things that otherwise people would normally be paying for themselves, but they're running through their business. I'm not familiar with any Utah cases where we're talking about a partnership, only where one person is self-employed. And I'm certainly not familiar with anywhere there's a partnership where one partner owns 75% of the business and the other partner owns 25% of the business. Just as a framework, I think it's sort of an interesting concept. Let's say you have like two lawyers that are partners and they buy jazz tickets. Does that mean that like they could maybe have made more money if they hadn't have bought the jazz tickets, right? I think that that's where Ms. Ward's argument is headed. What does that look like? But she's asked globally for that whole framework to be applied. But as we've had a discussion this morning and in the briefing, I really think she's only talking about the ranch. I don't think we're talking about the entire framework of gross revenue minus receipts. That ship kind of sailed. They started down that path with the credit cards. The trial court was rejecting it, and the trial court did make factual findings rejecting that approach. And that's bolstered by the fact that they didn't bring that up at all in their closing argument, in their presentation about the three things. The credit cards aren't in there at all. So I think we've got a waiver, an invited error, and any way we have findings on that topic. If what they wanted was more findings about the credit card, they needed to ask the trial court to make those findings. We don't have a briefing here that's simply asking for a remand for more findings on that topic. So I don't see this as actually being a self-employment case, at least in the traditional sense.
And I guess that's what I was gonna ask you. Help me understand, should we be focusing on the imputation part of this, or should we be focusing on the trial court's determination about under the statute, under 2034? Whichever one we're talking about, current or 2017.
Well, just on that point, I think you should use the old one because the language has changed somewhat. Okay, so your question had a couple of different parts.
Yep.
So the imputation is a different way, right, of approaching when a person's income doesn't actually reflect their wages. And that feels to me like the framework that was actually asked for here, because they asked for an add up, right? Here are his wages, but we don't think that's the right number. We think it should be higher. Normally when you're doing a self-employment case, you're taking gross revenue and you're working down from that. This looks and feels a lot more like an imputation case building up. So they've asked to build up with three things, one of which we agreed to. Okay, fair, we'll add that on. The next piece is the wife's income, and it's his current wife, not his ex-wife, his current wife's income, but the trial court made a finding. We're not gonna include that. That's her income. The fact that she also has another job is neither here nor there. Okay, that's her income and she legitimately earns it, and I'm not gonna include that. And then we get to the ranch. And the ranch is its own piece. So going back to your question, should we be looking at it as an imputation case? I think it's more of an imputation case, but what matters is that the trial court made findings on all the things it was asked to. And so if you've got findings on all of the things you've asked to, then it's just an abuse of discretion factual finding case. I don't see any kind of statutory error here. Does that answer your question?
It does. I mean, I guess it's just, it is, the court made findings, but the court never specifically set out, and I guess this is more of an adequacy of the findings challenge rather than a sufficiency challenge, honestly. But the court never really said, okay, I choose not to, other than sort of indirectly and ultimately, I find that but I guess it did. I don't know. Maybe I'm just confused about the adding back in the ranch laws. I mean, I guess the court did make findings about that.
It did, and I think the reason it didn't say this is a self-employment case under 2034 or this is an imputation case under 2038 was because the way that Ms. Ward framed it up at closing argument was, we've got this and we want to add in A, B, C. And the trial court said, okay, let's talk about A, B, C. And it accepted that framework. That's why we started off with like a waiver or invited error issue, because the court followed the framework that was presented. And I don't think you get to come up on appeal and say, actually, it should have used a different framework. So moving to talking just about the ranch, I don't know if you can apply the self-employment piece just to the ranch, but hypothetically, let's say that you can. The trial court made findings that it was a decision made by Roy, that Meredith wasn't even involved in it. Now, during her opening argument, she said that Roy had said that we were 50-50, we were in everything. That's true. He said that in 2013. The record site for that is like 212. But by the time we get to the ranch, many years later, things had changed. And Roy testified that as to the ranch specifically, Meredith wasn't involved in that conversation at all. Roy and his accountant decided that that's what they were going to do, and they were going to go buy it. The trial court thought that that seemed completely copacetic. Like, this is, you know, Roy's the CEO. He owns 75% of it. He's made a one-time investment. And Ms. Ward would like to take Roy's decision to make a one-time investment and add it to Meredith's income. I don't think any statutory scheme would support that. And anyway, the trial court made a finding that it was fine and that it wasn't going to include it as income. It doesn't have to include everything as income, right? The statute tells us what gross income means, and it doesn't have to include absolutely everything available. So the trial court had many reasons to reject it and did reject it. And we haven't had an adequate discussion as to why those findings are incorrect. I think that gets us through all of the things with Meredith's income. We're down to what his actual income was, and he agreed to go higher. And as Judge Mortensen pointed out, I don't see how you could possibly say that if the findings say $18,000 and Meredith agrees to pay $32,000, that would be improper. And as we said in our brief, if this court were to reject that, I think we're down to $18,000. That doesn't mean we're up at the $70,000 or $80,000 number that they're asking for. The findings are $18,000. I have no other.
Can I follow up on, Judge Harris asked opposing counsel about paragraph 46, that's cited on page 41 of the red brief. Petitioner never filed any statement of discovery related to inadequate disclosures related to financial disclosures. You're standing by that statement?
I'm standing by that statement unless I'm pointed to a record site otherwise, but I wasn't given one an opening argument. I don't know how to check it in the record to know whether, yes. We're standing by that statement, and also we're standing by the finding that the trial court made that the trial court found it wasn't going to sanction. I'm not familiar with any case, and I could be wrong, but I don't know of a case where, and one was not cited, where this court reversed a trial court's decision not to impose sanctions.
What's your view of exactly how the sanctions request was made? Was it made sort of at closing argument at trial orally, or was there a written motion for sanctions somewhere that we can go find in the record?
I don't think it was made at closing argument. I think it was made, I think that was a written motion.
You both filed motions for sanctions, right?
Right, sort of
In fact,
throughout.
I think you started, if I'm reading, I tried to read the record as best I could. It's a little bit lengthy, but from what I could gather,
You're brave.
you fired first, and then there was a cross motion, kind of like not, fighting yours and saying, actually, it's us who should get the award of sanctions.
Well, I think that may be right, and I think that may be why the trial court ultimately didn't impose sanctions. I don't think it's accurate to say that only one party in this case has strung things out. And so the trial court may have thought, well, we're just not going to go down this path. But I also am leaning partly on Rule 24, which says that the argument has to explain with citations to legal authority what's going on here. And the fact that we're having this conversation at all suggests that we don't know exactly what the target is and what the legal framework is that she's asking this court to appeal under. And so I would suggest that you should affirm the court's decision to not impose sanctions. And also, she's leaned on Rule 11 partly, or more significantly in her brief, The discussion about Rule 11 in her brief is actually associated with appellate attorney fees, not with sanctions. And I think we've responded to that adequately in our brief.
41, the record said, it appears to be 4117.
The record,
Petitioner's motion for Rule 11 and Rule 37 sanctions against respondent.
is it, I can grab my computer, is it tied to,
And that was after respondent filed his Rule 11 motion for sanctions against petitioner.
is it tied to his financial disclosures or Rule 26.1 disclosures?
All I have is the docket, I don't know.
Judge Mortenson's gonna look, you can keep arguing.
Well, I have nothing further. I would ask this court to affirm unless you want me to stay here.
I think you're good. Thank you, Ms. Nelson.
Thank you. I'm sorry, what was that record say?
His was 4108, and then hers was 4117.
I've been sitting here, counsel, going through a few of the citations that you mentioned. The first one was a motion for authorization to get bank records.
Because they weren't being produced.
But you would admit that a motion to get authorization to obtain bank records is not a statement of discovery.
No, but our statement of discovery issues is at docket number 665. That was filed September 25th in 2018, and then there were numerous follow-up hearings.
That wasn't one of the numbers you gave me, so I'll have to look at that anew.
Okay,
That's 3689. But I don't have it in front of me.
okay, so, yeah. So Bates 368, or the record number 3689, but yes, if you're looking at the green filing docket at 665. Thank you. And so that was an example of a statement of discovery issues, but then we had repeated motions before the court where the commissioner, she used to work through these issues in an interesting way where she would often take the parties back into chambers. And that was part of the issue when we were here on appeal before, is she had done that same thing where there's no record essentially made. But we have that filing of the statement of discovery issues, which is one example, but then the other citations, as stated, yes, we were going to the court, motioning for bank records, motioning and filing subpoenas for records with the company itself, and obviously we didn't get any cooperation when we subpoenaed Iron Mountain or McGarry Livestock. We got those subpoenas on there as well that were served, but then we had to ask the court and take the extreme step about getting the taxes because they just weren't produced. Again, it was 28 days before trial, just as a pretrial disclosure after 10 years of litigation, as if it meant nothing.
So let me make sure I understand what it is you're asking us to do with regard to the sanctions issue. You said you were asking for some sort of global determination of reversal, but what is if you were writing our order for us, what would it say?
Right, or at least review of the record on remand for reconsideration. Because essentially, if I'm writing the order for you, I would, it kind of goes back to our second point in argument that again, this is something not consistent with the evidence of the record.
Well,
where-
would the order say that the court is to impose some sort of sanction and the court is then to go back and look at the record and choose that sanction? Or would our order stop short of that and just say, hey, go back and reconsider the whole matter?
I guess it could be crafted either way. I think that it would be.
Or do you want us to pick a specific sanction?
No, I'm not asking this court to pick a specific sanction. I realize that that is usually well-founded and within the authority of the trial court, but we don't feel that there was adequate review. For this, just for example, the supplemental order took nearly a year to issue from the time we had requested it. We'd been waiting and waiting. Finally, we had several follow-ups with the court. It was beyond the 60 days. The judges have beyond even 90 days for review and for matters taken under advisement. And so when we asked to finally get that decision, I don't know if it's something that was carefully reviewed and considering the evidence of the record. Again, the findings just don't support, the evidence just don't support the findings. And so we're taking issue with that to say that it was something dilatory when we had, again, numerous motion hearings. We had to take so many steps to send subpoenas, to ask the court by way of motion for bank records for taxes, when we did statements of discovery issues. And we also had a counter on another statement of discovery issue. That's at docket 715. That was respondent's statement of discovery issues and motion to quash. And again, we took issue with their non-disclosure, even though it was their motion on that one as well. So at docket 665 and 715, that's both in 2018 and in 2019. And so again, it's been this ongoing problem where there's just been non-compliance, non-disclosure. And to say that Meredith isn't the only one that's delayed is incorrect, because Ms. Ward regularly, repeatedly, constantly updated her Findex. She always provided when she got raises. We always updated, and the record shows that. The record reflects that she was always disclosing her income.
What was the sanction you were specifically asking for in your motions below?
In our motions below, we were asking for reimbursement of fees because this has cost Ms. Ward
So
an exponential.
you weren't asking for negative inference instructions or striking of pleadings or anything like that. It was money.
It's not just money. We were also asking for entry of default. We did ask for that. We also, that certainly didn't happen. It's a long shot to get that to happen, but certainly heading into trial.
Are you claiming now that should have happened and that our orders should direct the court to enter default of some sort?
It would be great if that could happen, but at this point in the process, we had a hard time even getting a trial. They were trying to deny due process here. And so when we finally did get that trial, it's just that it seems that Ms. Ward can't catch a break here. She's not able to get a fair day in court where she's bringing actions under the law. She's trying to have an application of the statutes. I also disagree with counsel's rebuttal. We've submitted our addendum on our reply brief that shows our full closing statement, our full closing argument, and we absolutely did argue the application of the statute there under 403. Obviously, it's the prior, before the renumbering of just went into effect this month. But again, or I'm sorry, not 403, 203, 4A. And our closing argument lays out essentially the requirements of the statute for a self-employed person.
Right, but the way you argued 203-4A was framed by the three things, right? You said, apply 203-4A, and here's how we want you to do it. Add back these three things.
So
right? Am I missing that?
that is our argument, but I want to explain why. Because the statute doesn't, so what the statute requires is that you only take expenses necessary for operation of business. So those three things, we're saying, whoa, whoa, whoa. First off, he's hiding income over here, pushing it off under his wife. That's as to her income, also trying to now assign her a share of his percentage, which was never raised previously in the litigation. But then also, we do have the big ranch issue and all the deductions that were taken there, because the statute, so section 203-4A, is silent to that point. It doesn't tell you what to do when you have expenses that are not necessary expenses for business operation. So that is a part of what we took issue with. It doesn't say, the statute doesn't allow them to go off and make future investments. I mean, both Roy and...
So your answer to my question, I think, is yes. That you are asking the court to apply the statute in this particular way with the three things.
Well, because maybe it's because a matter of first impression, we don't have case law to say, what do you do with these other expenses that are not necessary business expenses? So what do you do with them? We would think you would add them back in to have considered as part of income. That's the argument we were making, because the statute doesn't say, it does specify that it's only for the expenses necessary for business operation. For the necessary expenses to operate a Utah construction rebar company, it's not necessary to have a ranch where you have four-wheelers and campers and trailers and side-by-sides and you're having fun and going on vacation.
I understand the argument.
Yeah, that's not necessary for the operation of a rebar construction company in Utah to go have a separate ranch to play on in Idaho. And for them to say, well, maybe someday it'll turn a profit. Maybe someday, we're looking at it maybe as a future investment. I mean, that's a lot of excusing away of a big chunk of money that's there and available for the business that they decided to spend elsewhere. That doesn't mean that that should not be considered in the income calculation for purposes of child support. And that's the crux of our argument. So yes, we are saying add that ranch back in then and consider that, because that's money that they chose to spend elsewhere and it's not necessary for the business operation. And so again, where the statute is silent on that, because the statute clearly sets forth what you are, like essentially the statute sets forth how income is to be calculated when they're self-employed. Certainly, there's no question here that Mr. McGarry is self-employed. And again, where we're saying the evidence doesn't align with the findings, we don't think it's just at a 25%. We made those arguments left and right, and even if the judge wants to reject those, then we'll just go along with what the judge said and accept the 25% that was imputed to him. But again, that's a percentage, that's his business interest for the company that he started, that we essentially believe he's hiding through his brother, hiding through his wife. But we'll go ahead with the 25%, and that's what we did in our closing argument. We said, and that's his admitted income on his FinDec. Mr. Olson and I were in agreement on that at the time of closing arguments. The only thing we weren't in agreement on is what should be added back in. And again, where it's argued here, it doesn't matter if the wife is employed elsewhere. Well, we believe it does, because the testimony, as we briefed it, we've cited to the record where both Mr. McGarry and Roy were making statements. Yeah, she works for Iron Mountain. Yeah, but then they couldn't specify a single actual part of the job or her job description that she does for Iron Mountain. And in fact, they testified to the contrary, that her primary work is actually keeping the books for McGarry Land and Livestock. That's a whole different thing. And then here they are depreciating the ranch through Iron Mountain. And so again, we're taking issue because it's not matching up, it's not adding up, and it's certainly not compliant with the statute, the prior 78B 12 203 4A. And so when we had that application of that law at the time, again, the statute doesn't give us a direction. And that's where I say maybe it is a matter of first impression, because the statute doesn't tell you what to do with all those expenses, especially here where it's a very large expense, what to do with it. And so that's where we're saying, well, if it's saying you only look at the necessary expenses for operation of business and you deduct the gross receipts, well, that's essentially, then what do you do with that other very large expense over here that's not necessary for business operation? Then you would consider that as part of their income. That's our argument. Does the court have any follow-up, final questions?
Doesn't appear so.
Thank you.
Thank you very much for your arguments today, counsel. We appreciate them. We will take this matter under advisement and render a written decision as soon as we can. Thank you.